Hello viewers, this is attorney Naresh Gehi, and we are going to talk about a very important subject today, commonly referred to as the fraud waiver under immigration law. So I'm going to start this with an example. You have a relative abroad that you sponsored, and your relative, for example your spouse, went for an interview there, or your child went for an interview back home, and when he or she met the consulate officer said, well, unfortunately, you have committed a fraud in the past, and this fraud relates to an immigration matter, and therefore you have to apply for a waiver. So now you're confronted with a very difficult situation, because you can apply for the waiver, but it's very difficult for you to actually get the green card sometimes if you cannot prove extreme hardship to your US citizen relative in the United States or to a permanent resident in the United States. So the law on the point of 601 waivers is that you need to prove extreme hardship, which is not an easy job. The reason I can tell you this with the highest level of confidence is because over the years, our law firm has done a lot of waivers involving immigration fraud, commonly referred to as extreme hardship waivers. And we've been successful in a lot of them, but prior results do not guarantee future outcome. Of course, you cannot win every waiver, but we've been highly successful in fighting these cases before immigration. So now, what are the requirements for the fraud waiver? Now, let's take this example that your son went for the interview in a consulate in a foreign country. They went to the UK in London, or you had someone who went to the consulate in Nairobi in Kenya, or someone went for an interview in Mumbai. So now, or in Dhaka, or in Islamabad in Pakistan, or before Georgetown in Guyana. So now the thing is that exactly the first thing is that the consulate officer gave you a paper, and on that paper he wrote very clearly, you are eligible to obtain a permanent resident visa. However, you are eligible to apply for a waiver. So at least there is some hope that you have. What should you do in this case? Even if you have an existing lawyer, you have the right to change your lawyer. Or if you did the paperwork on your own, immediately go to a lawyer who is very good at handling immigration waivers. And I'll tell you why. Because proving extreme hardship is not an easy job. So therefore, in order to prove extreme hardship, you need to make sure that you have to demonstrate the hardship in a very, very serious way to show that the US citizen's life will be absolutely devastated if this person abroad does not get a visa. For example, you're married to someone back home, and now your entire situation is terrifying because you just heard from the consulate that the person needs to apply for a fraud waiver. This is serious business. So what does the lawyer have to do? He has to show that basically, beyond a reasonable doubt, that's the standard I use in my mind, but generally the standard is clear and convincing evidence in immigration. So we have to show by clear and convincing evidence that the US citizen spouse or the green card holder spouse in America is going to suffer drastically. Now, after that, what happens in our firm, we also get in touch with some of the experts to make sure of exactly how we can make this case very strong. So the bottom line is, just by filling up the waiver form and writing a simple affidavit means nothing. Because even the consulate will tell you, make sure that when you are asked to apply for the waiver, show as much evidence as you can to demonstrate the hardship. For example, if the person has a health condition in the US, other than that, there is no way the person can go back and live in that country. There are a host of different factors. What some people do, they just write a simple affidavit or a simple letter. My life will be devastated. Suddenly you get this letter in the mail. We regret to inform you that your waiver has been denied. Now that's not a good thing for you. If the waiver gets denied, of course, we have also won cases wherein people's waivers have been denied. So anytime if you are applying for a fraud waiver, the section under the law is under 212I of the Immigration and Nationality Act. A person can apply for the waiver. Now, in order to be eligible to apply for the waiver, the hardship has to be shown to a U.S. citizen spouse, a green card holder spouse, or to a parent who's a U.S. citizen or a green card holder. So if you have the situation wherein even when you went for an immigration interview in America, you sponsored your spouse or someone, your parent in America, and now after the interview, the officer is asking you to apply for a 601 waiver, immediately get in touch with a very good law firm that knows about immigration waivers, that knows about fraud waivers, and if you do the right thing, the good news is that your spouse or your parent or your child may qualify for a green card. We've handled a lot of similar cases. Prior results do not guarantee future outcome. We have 3 offices, one in Forest Hills, one in Ozone Park, and one in Jamaica, and we can be reached at 718-263-5999 for a free initial personal consultation, and our email address is info@gehilaw.com. And if you want to come in and reach us in our Ozone Park office, the number is 718-577-0711. This is Attorney Naresh M. Gehi speaking about fraud waivers under immigration law. We'll be back with our viewers with some more interesting news from the world of immigration on our shows on YouTube.